Welcome to the beautiful Dying Expo. I'm Althea Halchuk, final exit surrogate consultant, and in that role, I help surrogates and healthcare proxies who may be having trouble enforcing an advance directive. I also answer questions from members about their directives and their living wills. In my program today, I'll review advance directives, offer tips on choosing an effective surrogate, and having those advance directives your advance directives followed. I also describe FEN's surrogate consultant program and offer a case study. The key to having your healthcare wishes honored is choosing a surrogate who will speak for you and make sure your treatment wishes are followed. Your surrogate is so critical to the success of your advance care planning. It's the first question in any advance directive. Who will be your surrogate? You want a bulldog. Final Exit's mission is about choices, options, and education at the end of life. Listen to Ben. By failing to prepare, you're preparing to fail, because having no plan can lead other people to choose critical care for you when you can't speak for yourself. Often you get the treatment you might not have wanted, or you'll have decisions made by a person you might not have chosen. Here are the poster girls for failing to prepare. Karen Ann Quinlan, Nancy Cruzan, and Terry Schiavo were all in their 20s when they ended up in persistent vegetative states with no hope of recovery. Karen Ann was at a party and she mixed alcohol and drugs, and there was the interaction of those caused her to lapse into a coma. Nancy Cruzan was in a car accident. Her car flipped over on an icy road and she ended up in a ditch, and they found her and revived her, but again, in a coma. And Terry Schiavo had a cardiac arrest. These women were all in their 20s. The reasons, all three ladies were artificially kept alive for many years because none had an advance directive. After many years of fighting, the courts ultimately gave the three families the right to discontinue life support. These women all had landmark cases in the right to die movement and the need for advanced care planning, but the pain for their family and friends cannot be understated. Don't let this happen to you or your family. Create an advance directive and have the conversation about your treatment wishes with everyone in your circle, family, close friends, anybody who might affect friends. Here's a quick walk through advanced care planning. Only about 30% of Americans have advance directives, up from 25% since the COVID pandemic, when many people found themselves in a ICU, unable to speak and with no plan. The basic parts of an advance directive are number one, choosing your healthcare surrogate, granting authority to someone you trust to act on your behalf when you cannot speak for yourself. The other part is the living will, which contains your healthcare and medical treatment wishes and body disposition at the end of life. You can spell out your memorial or funeral plans, organ donation, and any other end of life choices. You can pre-plan it all. Effective advance planning requires you document your wishes, sign your advance directive in front of witnesses or a notary, depending on your state, share copies with your surrogate and family, and video and update as needed. Advance directives are state specific. Advance directives are state specific, so to be sure to pick one approved by your state. Although every state offers free forms, they are often full of legalese and are cumbersome to fill out. I usually recommend 5 Wishes, which is easy and legal everywhere in the United States. 5 Wishes has a link to each state spelling out any extra requirements to make it legal in your particular state. Indiana, for example, requires a 1-page living will form downloadable from the state that you attach to your 5 Wishes form. Other states have special signing requirements, like 2 witnesses or signing in front of a notary. Things happen, be prepared. An advance directive isn't just for end-of-life wishes. A medical crisis can happen in the blink of an eye. Raise your hand if you've ever been in a car accident. How much worse would it have been for you and your family if you were in a coma in an ICU with no directive or surrogate to speak for you? Think of Nancy Cruzan. She was in a car accident. My 49-year-old brother-in-law had a massive stroke with no advance directive. These are survivable events, but living a good quality of life and merely surviving can look very different. So don't wait until it's too late or until you're too sick to choose your future health care. So what is a surrogate? A surrogate is a substitute healthcare decision maker. This person speaks for the patient who lacks capacity to make decisions. They implement your advance directive and consent or refuse some or all medical treatments in accordance with your wishes and your end-of-life goals. The best surrogate may not be your spouse or your child or even your best friend. By the way, your appointed decision maker may go by many different names. The most common variation include healthcare agent, proxy, representative, medical power of attorney, or any other authorized decision maker. Regardless of the terminology, it's the individual who's recognized to make decisions on behalf of an incapacitated patient. Here are the top 6 traits to look for when you're choosing an effective surrogate. 1, you want a person comfortable making decisions on your behalf, even if your wishes differ from theirs. This is about you and what you want, not about your surrogate. 2, you need someone with the emotional strength to carry out choice at the end of life. Some people might feel guilty or second guess themselves as your surrogate. Can they put these feelings aside and do what's right for you? You need to find out. 3, you want someone who'll stand up for your wishes and won't be intimidated, bullied, or guilted into something. They won't cave to pressure or back down when a medical request goes against your wishes, but will challenge treatment options that are contrary to yours. You want a warrior, not a wallflower. You want a person who isn't afraid to ask questions or ask for help. A surrogate isn't expected to know everything. Experts are readily available to lay out options and give the surrogate guidance, but they need to know what you don't know. Your surrogate should seek help from others if they feel ignored, overruled, or outnumbered. Help can come from the hospital ethics committee, a legal or compliance department, or me as final exit surrogate consultant. 5, you want a person who will remain calm in a crisis or in a quickly changing or emergent situation. If you're lost at sea, this is the person you want in your lifeboat. Someone who will remain calm and make good decisions. 6, most important, you want a person who agrees to be your surrogate and is ready, willing, and able to serve at a moment's notice. A person who understands your wishes and who will enforce them. Not what happens if I don't choose? Well, not choosing is the same as choosing, because if you don't choose, the choice will be made for you, and it may be somebody that you would never want, like your least favorite sibling or your eldest child who's irresponsible or worse. Here's old man Winter in an ICU all hooked up, and one brother says, let's keep him on life support. and the other one says, I say we shouldn't let him linger. Well, here's two different opinions. And so what is a medical team to do? They want the family to agree. Another common scenario is for a faraway relative who hasn't even seen the patient in a year, who swoops in to tell everyone what they think about what should be done. I heard a hospice doctor describe them as pigeons. They fly in and they crap all over everything. Every state has a hierarchy of decision makers when you don't appoint someone. This is the slide for Arizona's hierarchy, but many states are similar. Other states have no system at all. A common order of decision makers is a guardian appointed by the state or court. They're always the highest. Your spouse or registered domestic partner, adult children, parents, adult siblings, adult grandchildren, and adult nieces and nephews and close friends. Sometimes the domestic partner is below the parents. It really just depends on the state. Sometimes it's the attending doctor who can authorize a decision maker among family members present. Some doctors choose a staff social worker, a person who may never even have met the patient. Quite often, the medical staff will turn to anyone in the room to make decisions for an incapacitated patient, even when there's a named surrogate. Or the medical staff will try to reach consensus among the family. My brother-in-law, who had the stroke, the neurologist described what his stroke was. It was the worst kind, and he was bleeding into his brain still. And two brothers said, well, he doesn't want to live this way. And the third brother, who never got along with the patient, kept insisting he wouldn't let him go. But that brother overruled the patient's stated wishes. So the default is to preserve life if the family doesn't agree. 5 years later, he's still alive and living as the neurologist described, not a quality of life he would find acceptable if he had a choice. Expectations. Have many conversations with your surrogate about your expectations. People assume that others are on the same wavelength when it comes to treatment wishes, or that they understand your goals and values. Spell out your needs, how you expect your surrogate to answer, and carry out those needs. Is there any wiggle room for the surrogate to make decisions beyond what you have in your advance directive? You want to strike a balance between granting detailed power, but leaving enough flexibility to address unforeseen issues as long as it's a decision in your best interest. You need to have many candid conversations about your treatment issues. This isn't just a one and done. You really need to talk to your surrogate, your family, anyone else who might be contacted about your medical condition in an emergency. Nancy Cruzan was finally taken off life support because after the U.S. Supreme Court denied her parents and put it back to the lower court accepted the testimony from her friends that she stated she'd never want to live like a vegetable. The court finally allowed her to die. This is how important the conversations are. Again, she had no written directive. What does quality of life mean for you? And at what point would you consider withdrawing nutrition and hydration, if ever? Will your surrogate be able to move you into a care facility or hospice? Can they decide to provide only comfort care and no antibiotics if you get an infection? Think of the advance directive as a roadmap and the conversations with your surrogate as the directions on that map. Be sure to have a plan B, because what happens if your Surrogate is not around, not available, no longer willing to act, has died. Choose more than one surrogate and not a surrogate committee or even co-surrogates. To avoid conflict or misunderstanding, it's best to have one person at a time deciding for you when you can't choose. Keep in mind, if you choose two people or to three or a group, such as all of your siblings, to make these decisions, all of them must agree to your care, or you may not get what you want. So just like in my brother-in-law's case, one brother had the ability to overrule two other brothers who did know what the patient wanted. So make sure only one person is your surrogate and decided, and it's always best to plan ahead. Pick two, pick three. Here are some things to consider. Creating an advance directive isn't all that complicated, but you're stating wishes based on future events. Remember, you can revoke your surrogate and appoint a new one at any time, as long as you have capacity to do so. Your wishes can change over time as you age. You might now have grandchildren, so that may change. 3, consider using a lawyer if your situation is so complex, but you really don't need one to create an advance directive. You can revoke your advance directive orally by telling your healthcare provider you no longer want the advance directive or any part of it enforced. You can't have any crossouts or add-ins in your advance directive. Any changes to the directive, including a new surrogate, require a new advance directive. Be sure to destroy old copies and give your new advance directive to your surrogate and family. Copies are as good as originals. 7, the last advance directive date is the one that will be enforced. Reviewing your advance directive, the 6 Ds. Review your advance directives every year, such as on your birthday or Healthcare Decisions Day, which is always April 16th, day after tax day. Follow the 6 Ds. This is courtesy of Jane Markley and Thad Pope, who use this term. 1, decade. Every 10 years, probably too long as you age into your 70s and 80s, but it's fine when you're a young adult and you're healthy. 2, you have a decline in your health. Are you having a lot of health issues now that you weren't having 2 years ago? You may want to look at your advance directive based on that. Diagnosis, you're healthy one day and then the next day you get a cancer diagnosis. Suddenly your future scenario is here and you may want to make some adjustments. Divorce. In most states, after your divorce is final, your ex cannot act as your surrogate, but there are some exceptions, so be sure to check in your state. The distance of your surrogate. It's best if the person is local, but it should not be a big factor with telemedicine. The surrogate can be right in the ICU, in the emergency room, and be 3,000 miles away. The death of the surrogate or a loved one, you should review your advance directive because you're going to have to choose a new surrogate if that happens, and there may be some other things to consider. Why do so many advance directives fail? It happens pretty often, and really there's reasons behind this. A copy wasn't provided to the family or the doctor. The AARP says 35% of advance directives can't be found. So keep it handy, give a copy to anyone who might be called upon to make healthcare choices for you, and keep one in your glove box in case you're in an accident. Another thing is you can, there's emergency phone contact numbers. If you're in an accident and you have your cell phone and the EMTs, you're unconscious, the EMTs can look at this emergency contact number on your phone and call that person. So they don't even have to see your advance directive. They're going to contact the person on the phone because that's quickest. 2, others are unaware that your advance directive was completed or even where it is. No one knew the advance directive existed because people get queasy talking about death-related topics, so they never told their family. Let your family know where it is, where you keep it, and please never put it in a safe deposit box. You'll be dead by the time the court allows someone to open up the box to find out what you want. A surrogate was unaware they were chosen. The Heart of Hospice's podcast, Helen Bauer told me her story about her surprise surrogacy. She got a call from an ICU asking what the staff should do for an incapacitated patient who had named Helen as the surrogate. Helen was a hospice nurse, but she was unprepared for being this woman's surrogate. She barely knew her, and she never had a discussion with her about any of this. It's a compelling story and a cautionary tale. Please make sure your surrogate, that the surrogate you choose, wants the job. It's a big responsibility, and they need to agree to accept it. Another reason it fails is the surrogate was unavailable for whatever reason. Out of the country, getting a back rub, it can be anything. They're just not available when the call comes. So unless you have somebody else chosen. 5, surrogate refuses to follow the directive. Well, it might have seemed like a good idea at the time to be mom's surrogate. Having to turn off her ventilator can be emotionally problematic for many people, and so they refuse to follow the directive. 6, family members disagree on what the best care is. The biggest source of conflict in the ICU at the end of life is family disagreement. Remember the swooper? If you had an advance directive and named a surrogate, only that person has the right to follow your advance directive. And hopefully he'll be in there, or she will be in the room with your advance directive and their authority to make decisions for you. So it doesn't matter what the swooper says. 7, a doctor disagrees with your advance directive because the provider is morally opposed to honoring your wishes, or he thinks or she thinks they know better than the advance directive. More on that later. The surrogate's understanding of the options differs from what the patient meant. So they have their advance directive, the surrogate has been chosen, but now there's some kind of term that really the expectations weren't met. Extraordinary efforts are heroic measures. That one is used very frequently in these boilerplate advance directives. Pacemakers used to be extraordinary, but now they're routine. However, they're difficult to turn off at end of life. If you become incapacitated at the end of life, would you want a pacemaker or even antibiotics? How about resuscitation at age 80 or 90 when the odds are likely that you will not survive? It isn't like TV where everybody gets up and walks away. That's rare, actually, and especially in somebody in that age group. Once they go in, under what circumstances would you want a feeding tube? Once they go in, like pacemakers, it isn't easy to have them removed. Spell out your treatment and non-treatment wishes in clear language. Ooh. Quality of life. What does it mean to you? And at what point will you find the quality of life, a quality of life you have, unacceptable? Is it when you don't recognize family or friends? Is it when you can't toilet yourself, have to go to a nursing home? The line in the sand is different for everyone, and it can change over time. So make sure you both know where that line is. Spell it out. Lastly, avoid the phrase, no hope for recovery. It's so vague, it leaves the door open for a doctor or even a surrogate's interpretation. Some will say there's always hope or miracles can happen, and then they'll feel free to provide additional treatment, even if it's futile. Now, medical providers can refuse to honor your treatment wishes if they have a conscientious objection because a medical direction goes against their religious or ethical beliefs, or they consider your wishes medically inappropriate or outside their scope of practice. They can refuse if the director goes against the facility's policies, such as a Catholic hospital, in a Catholic hospital where they have policies that might go against your choice of treatment. In these two situations, the provider or facility must tell you right away they won't treat you. They have an obligation to help transfer you to another healthcare provider who will comply with your wishes. Here's the best chance of having your directive followed. The person understands the directive and clearly spells, the person writing the directive clearly understands it and spells out their wishes. The surrogate understands the wishes and agrees to follow them. The physician or staff are aware of the advance directive and they comply with the surrogate's instructions. A person always provides updated contact information for the surrogate so they can be reached quickly in an emergency. And having a contact phone number on your smartphone is one good way to make sure that the right person is contacted. The person continues to have the conversation with their family, friends, and especially their surrogate. You always carry a wallet card and your surrogate's name with your surrogate's name and contact on it. You can have a small card, laminated, name, phone number. This is the person to call in an emergency. Keep it in your wallet, keep it in your glove box. Create a personal statement about your treatment wishes. Leave no doubt about what you want, what you don't want, and how you made the decision. Did you read books, see movies, experience a bad end of life with friends or relatives? Include it in your reasoning about why you want a particular treatment or not. Finally, consider making a video. When you can create your advance directive and each time you update it, use it as a backup. There's nothing like hearing it from the horse's mouth if your surrogate needs to prove your wishes either to the staff or a know-it-all swooper. Also, it can be reassuring for the surrogate and the family to hear your wishes from you when you still had capacity to state them. Keep it on a thumb drive with your directive and make sure it's time and date stamped. There are companies that will help you video your advance directive. And I have a link to some in the resources. The right to choose has been, the right to choose, in 1914, Judge Benjamin Cardozo stated, he was a Supreme Court judge in New York, he stated, every human being of adult years and sound mind has a right to determine what shall be done with his own body. And I read the slide because it's probably the most important thing about healthcare. And in the middle of a vaccine mandate where people are not being allowed to make their own decision, I think in all of these court cases, it's going to come back to this kind of thinking that we all have a right to determine what shall be done with our own body. And it was codified into federal law by the Patients' Self-Determination Act in 1991. And it was, again, thanks to Nancy Cruzan that this law was adopted. After her parents lost their case in the Supreme Court, it shined a light on the need for advanced care planning. She didn't have it. Once it went back to the lower court, they accepted verbal testimony from her friends who said what she wanted. So here's some strategies to use when facing conflict or pushback from medical staff. Maybe the best strategy, you're the surrogate, you're the person who has named you is in an ICU, unconscious, and people are saying, well, we want to put in a feeding tube. That's a popular one. You say, if you know the patient absolutely never wanted this, loud and clear, you're doing this treatment without my consent, and I want my lack of consent put in the patient's medical record. It's important to leave a paper trail. Insist the denial be put in the medical record. Carry a medical POA or advance directive with you. Don't rely on the facility having access to it. A lot of times they don't. You give it to them and who knows where it goes from there. Advance directives are legal documents, and doctors have a duty to respect them and listen to the surrogate's direction. If someone acts against a directive, they can be found guilty criminally and civilly and required to pay damages. Recently, there's been many wrongful life and other types of lawsuits where a provider or facility ignored the surrogate's orders or went against the advance directive. In some cases, the staff kept the patient alive, prolonging their death and leaving the patient and family to suffer emotional and financial injury. The defense used to be, how is it wrong to keep someone alive? When I was on an ethics committee in California, there was a case where a man brought his wife into the emergency room, and she had an advance directive. He gave it to the ER staff. Then she was brought to the ER and she was moved into a room. The advance directive never made it upstairs to the nurse's station, and so they gave this woman CPR, and it went against her directive. And she had some really serious health issues, and she didn't want to be kept alive. And neither did her husband want that for her. So they kept her alive. They gave her CPR, they brought her back, and she lived for another week or so. And this man sued the hospital because it went against her advance directive. Why it didn't go from the emergency room to the nurse's station, we'll never know. But with electronic medical records, it seems like that should have been a no-brainer. And he was so distraught that he didn't bring it up to another department. So the rest is history. The defense used to be, how is it wrong to keep someone alive? Well, courts are now ruling that keeping someone alive goes in by going against the advance directive or surrogate's orders is a compensable injury, meaning you can get paid by their negligence to follow your advance directive. A young woman settled a lawsuit for over $1 million when a provider kept her grandmother alive with CPR, ignoring the DNR and her surrogate's directives. Just like this case where the man's wife was kept alive, same thing. The Supreme Court of Georgia justices denied the doctor's immunity claim, which was always what they claimed. It's the will of the patient or a designated agent and not the will of the healthcare provider that controls. So they are obligated to follow your direction as a surrogate and the advance directive. They can't go against that. Otherwise, they could be in real trouble. FEN offers its members a free surrogate consulting service. I don't suggest what's right or wrong with medical treatment. I help you enforce the advance directive of the patient. And if I can't help you enforce the directive by whatever method, I mean, I can go as far as having a consultation with you and the doctor and try to figure out like why they're not following what you and the directive say. If that fails, I can contact FEN's attorney and they'll determine what legal avenues are best from this point forward, including filing a lawsuit. And the service is free, including FEN's attorney. I have like a case study that I met this woman from the surrogate consultant service. I call them Diane and Bob. That's not their real names. But when Bob was first diagnosed with dementia, he wrote his advance directive naming his wife Diane as his surrogate. The couple carefully discussed his options, and his express wish was not to have any treatment that would extend his life. He knew what dementia looked like. He knew what path he was on. He didn't want to be kept alive longer than need be. After his doctor declared Bob incapacitated, Diane and the doctor signed a POST, which is a physician's order for life-sustaining treatment. It's like a prescription, which ordered comfort care only. As Bob's disease progressed, Diane admitted him to a facility that had a memory unit. For many months, Diane tried to have the facility enforce the pulse, but they kept giving Bob curative drugs and burdensome testing, not any part of comfort care. She contacted me for help. I urged Diane to draft a letter and send it certified to the doctor in the facility, spelling out drugs she wanted Bob to have or not have, such as antibiotics that would extend his life. She also told them to call her about any proposed treatments and to make her letter part of Bob's medical record. She's currently monitoring his drugs and medical record. So far, the facility is following her written notice, but Diane is prepared to sue the facility and the staff if they don't continue doing as she's directed. Fen will help her in these efforts pro bono. So Final Exit is here to help you, and they have a great website with many different resources that are free. They offer free education and support to qualified applicants facing intolerable quality of life due to intractable illness or pain, including those who do not live in a state where medical aid in dying is available and who do not meet its requirements. Medical aid in dying is great for those who qualify, but it's a very, very narrow. You have to be within 6 months of death, a resident of the state. Not all states have it. So Fen offers people another alternative. They offer the consultant service that I just talked about. They also offer SAD, it's called. It's Supplemental Advanced Directive for Dementia. It's designed to prevent people dying. It's designed to prevent dying people from being kept alive against their wishes when they have dementia. And that's another whole presentation. Fen also has the Good Death Society blog and many other great resources. So I urge you, become a member or sign up for any kind of information that they'll send you. My contact information, and anything in this presentation is only for information. It's not legal or medical advice. And that's my presentation. Are there any questions or comments?